Namaste, good morning to all the participants, and welcome to this 53rd webinar episode of AAA weekly webinar series. Today, the subject is very, very important, and we are discussing on the SEBI and stock exchanges compliances for all those listed companies which are under CIRP. So this subject is very, very important, very technical. So we have with us Shivam Gera, who is a company secretary, and he is the principal associate of Dolce Vita Trustees. We are also expecting another expert in this case, and that is Advocate Sumit Kochar. He is partner of Dolce Vita Trustees, and we would have some questions which are very, very important for our audience, for our participants. So, Ankit, on this 53rd episode, weekly episode, I will give you the lead. The biggest the change today we are having is that I am actually in a train, and one of my expert speaker, Advocate Sumit Kochar, he is presently at Mata Vaishno Devi, and he's trying to log in from Mata Vaishno Devi. In case he gets internet and he logs in, and that will be a very, very unique scenario of this particular webinar, where where I am traveling in a train, Ankit is at Delhi, and Shivam is uh, at another station, and one of the expert advocate Sumit Koshar is traveling at Mata Vaishno Devi. So when he joins, when he gets the internet, we will seek his expert opinion. And over to you, Ankit, for the basics of MCA compliances, and then we will come to the SEBI compliances. Over to you, Ankit. You can start.
So thank you, and I have shared the screen already. And the idea will be, of course, to quickly go through the compliances that are required under Companies Act, and then proceed with SEBI, because of course SEBI talks about extended compliances which are required for the purpose of listed companies. So I am going ahead, and the basically this is what is our agenda today, and let's start. So, brief pretext to
Ankit,
the.
one thing that I could understand, I think as Advocate Sumit Kochar is also joined through audio. This is what I could get the message.
Yeah, I think Sumitji
And
is here with us. So, Sumitji, maybe you can just confirm that you're listening to all of us, and you're able to speak as well. There might be some network issue at his end, so we will keep asking for Sumitji's input as and when I think he is able to join.
okay, all right. Ankit, please go ahead.
So, the entire powers of the board of directors are shifted to the interim resolution professional and subsequently to the RP. This is very clear from this pretext that is available on the screen before all of you. And therefore, the duty with respect to compliances falls on the shoulders of the IRP or the RP or the liquidator, depending on what stage the company is in. And therefore, it becomes the duty of the RP to ensure all compliances. And when we say all compliances, that includes ROC compliances and SEBI compliances. Non-compliance, we have a specific provision and also circulars from IBBI saying that if there is any non-compliance, that the penalties will not become part of the CRP cost. It will rather be personally payable by the IRP, RP, or the liquidator. So going forward, we have this Innovative Industries Limited judgment given to us by the Supreme Court of India in 2017, pretty much clarifying that even if there is a appeal which is filed by the company, even that is something that will have to be taken up by the management or by the IRP, RP of the company. And it cannot be something that the management or rather the board of directors continue. Uh, we, of course, know about this MCA General Circular dated 2020, which says that It is the IRP RP liquidator who is responsible for filing all the e-forms in the MCA portal and sign the forms in capacity of CEO in order to meet filing protocol. Any case where any of our listeners face difficulty in interacting with the MCA, this is the circular that you can use to seek cooperation from the MCA, and you can say that since this is an NCLT order which is in my name, appointing me as IRP, RP or liquidator, I am supposed to then act as a CEO and ensure these compliances. Let's quickly go through the general compliances under Companies Act. So board meetings, these are the annual compliances which are prior to CIRP. So it has to be done. Minimum 4 meetings have to
Ankit,
happen every year.
I
Yeah.
would like to pitch in here. Now, one that I have seen that Advocate Sumit Kochar has been able to join from uh, Mata Vaishno Devi. Sumit, can you switch on your video for a minute?
Hi, sir.
Yes. Welcome to this webinar, Sumit. It is indeed, it would be memorable webinar that you are actually speaking from Mata Vaishno Devi while you are actually climbing up to uh, the holy shrine. I am in a train, and this is the wave that we are managing. Please say hello to the audience, Sumit. And Sumit is joining today as an expert on SEBI compliances. And along with Sumit, we have Shivam
Hi.
Gera, and both are from Dolce Vita trustees. Sumit, thank you very much for joining. And I just wanted to say that for in the beginning, for all the insolvency professionals, it is very, very important to keep all the compliances, even if it is the compliances of the Companies Act or the SEBI or the stock exchanges. Any non-compliance, if any penalty is imposed, that penalty will be borne by the insolvency professionals in his personal capacity, and that will not form part of the corporate insolvency resolution cost. But the compliances that Ankit is now going to explain form by form, that's very, very important. Ankit, one thing is very important. You also please touch base, because in case of various companies where the compliances are pending for the last couple of years and the MCA portal would not allow you to file any document, then how do we use this GNL2 form and submit our documents by paying one-time fee rather than paying the fee for the last 5-6 years penalty and all that? Please also do touch this. Over to you, Ankit. And Sumit, and we are going to ask you some specific questions as the time will come. Yes, Ankit, please.
Great. So going forward, we talk about the AGMs that is required to be done. Then MBP1, that is again a disclosure with respect to interest in other registered entities. DIR2, where we talk about declaration for non-qualification, preparation of the director's report, preparation and circulation of the financial statements, appointment of auditors. So these are the compliances that are required to be completed with respect to the period which is prior to CIRP. The challenge here, which we feel that many RPs face, is a sanction with respect to completion of these formalities which might be pending for the period prior to CIRP, especially with respect to the sanction of the professional fee. We frequently see that the COC is more comfortable, especially in smaller cases, to complete prior compliances or spend money on prior compliances only when they see that a resolution plan is going to be approved. In some cases, we have seen that there is a thought process on part of the COC and maybe in sometimes even with the IPs that the resolution applicant will complete these compliances. From our experience, we can say that these compliances are then required to be completed altogether at the time of implementation of the resolution plan. And frequently the resolution plan will have clauses to say that these compliances should be completed at the end of the RP before the company is handed over to the new promoters or to the resolution applicant. So this is how this is normally how we see this functioning, and then of course the compliances have to be speeded up. So the best way and the best time to start these compliances, as we talked about earlier as well, is when the resolution plan is approved by the COC and maybe pending for approval before the NCLT. Annual compliances under Companies Act, of course, we continue to say that MGT 7, AOC 4 are forms that are required to be filed, and the compliance has to be ensured. These are some event-based compliances under Companies Act: change in directorship, change in registered office address, increase in authorized capital, change in the company's name, registration amendment, settlement of charges. So these are, again, event-based compliances that are recommended to be completed. These are forms that are required to be filed by the resolution professional subsequent to initiation of CIRP, and INC 28 is a form that is a must to be filed. The INC 28 is required to be filed in the following circumstances, which includes these provisions where we talk about admission under section 7, 9, or 10, then admission under 54C, approval of resolution plan, order of liquidation. These are the events when INC 28 is required to be filed. And this is a very, very important compliance. And I believe that most of the insolvency professional liquidators are doing these, completing these formalities. Filing of forms in the registry, MCA 21, by the insolvency professional or the liquidator. There is this General Circular 2020, which talks about how the liquidator has to first file the NCLT before the NCLT approving him as NCLT order approving him in INC 28, then jurisdictional ROC then shall approve the INC 28 form. Only once the INC 28 form is approved, the resolution professional who shall then he be able to file the forms on behalf of the company. So when we see MCA master data, we see a change in status of the company, and it specifically says under corporate insolvency resolution process whenever INC 28 is filed, and that's how then the CEO status is given to the insolvency professional through this process, so that the insolvency professional can make future filings. Then other forms, as Anil sir suggested, IP shall be allowed to file the same in his role as the CEO instead of the form being signed by 2 directors. So GNL 2 is where the IRP, RP liquidator can file certain documents with the ROC by filing this E-form. And in case there is no E-form prescribed for filing any document with the registrar, then IRP, RP liquidator can file such documents through this E-form. AOC 4, it is for filing the company's financial statements for every financial year with the registrar of companies. The company is responsible for duly furnishing the form within 30 days of the AGM. So every company in CRP or liquidation is required to file financial statements under AOC 4 within 30 days from the date of the AGM to ROC. So GNL 2 is what we then file, as Anil sir suggested short a while back, where we then make other filings before the MCA. MGT 7 is again an electronic form that is allocated to all the companies by Ministry of Corporate Affairs for filing details of their annual returns. So this is again something that is filed in this manner. XBRL form is then applicable based on the thresholds which have been provided for in these regulations, in these rules, and that's based on which then XBRL form is filed. The procedure to file INC 28, I will just quickly run through it. So visit the MCA portal in form INC 28. You have to select 5A3 by selecting the appropriate section of IBC, and then designation has to be put in as CEO. Choose others from drop-down box, and requirement to submit the form of change of status, active, inactive, CIRP liquidation. These changes are then this is done through the basis of form change request form submitted by IBBI to e-governance cell MCA, and this is how this compliance is then taken care of. So under IBC, of course, we have CIRP 1, CIRP 2, CIRP 3, and CIRP 4.
Ankit, at this moment, I think we now need to change a little bit regarding this discussion. Now, I would now indulge into what kind of compliances are required for a listed company.
Yeah.
First of all, I, according to my experience, whenever IRP is appointed and the company is a listed company, IRP will see various scenarios. One scenario that the company shares are still being traded as on the date of pronouncement of order for commencement of CIRP. That's one scenario, which is a most healthier scenario. Second scenario is that because of some non-compliances regarding the regulations, some non-compliances, the trading of the company is suspended. The training of the company is suspended. The training of the company is suspended for some time. And then the third scenario would be that the shares of the company are already delisted because of any other reasons. So in the first scenario, I think the IRP need to comply with all the requirements immediately within 30 minutes. Within 30 minutes of the pronouncement of the order, the IRP is supposed to inform the stock exchanges that the CIRP has commenced. That is what is the SEBI compliance requirement within 30 minutes. Now, this particular requirement, and then keeping all the compliances absolutely, as per the SEBI directions. Now, at this moment, I would ask one question from Dolce
Sure.
Vita trustees, that in what circumstances we see that the most of the companies are not being traded when the CIRP commences. So what are the reasons the companies are not active as on the start of the CIRP? I would seek answer from either Advocate Sumit Kochar or from Shivam.
Yeah, so basically when the CIRP has been commenced, so due to certain non-compliances, the listing of the company gets suspended. There are certain grounds prescribed by SEBI under the SOP, wherein the trading of the company will get suspended under certain ground. So once they comply with the listing regulations, they can apply for getting the revocation suspended. So revocation of suspending. So listing suspension will get revoked once the company applies for the same with the stock exchanges along with the requisite documents. In the requisite document, they have to take confirmation of the previous 4-quarter compliance of all the shareholding pattern, financial results, annual report. So once they have complied with all the regulations, paid the processing fees and the listing annual fees, they can get the trading of that company started on the stock exchange.
So Sumit, Shivam, tell me all those reasons why the trading gets suspended. All those reasons why the
Okay.
trading gets suspended either before the CIRP or during CIRP. I think there are about various reasons why the trading gets suspended. I just want that in case you can say all these 9-10 reasons for the benefit of our audience. Yes, please.
Yeah. So SEBI has prescribed criteria for suspension of trading in the shares of listed companies. So there are certain grounds during the CIRP wherein the listing can get suspended. So first is failure to appoint respect to the board composition. If they fails to comply with the board composition, it can get suspended. Also for the constitution of audit committee for 2 consecutive quarters. Also for the corporate governance compliance report for 2 consecutive quarters. Shareholding pattern for 2 consecutive quarters. If they fails to file this shareholding pattern or corporate governance compliance report, and also for the submission of financial result for 2 consecutive quarters. And along with the financial results, there is an annual report. If they fail to file annual report with the stock exchanges for 2 consecutive financial year, the listing might get suspended. And also the listed company has to submit the information on reconciliation of shares and capital audit report. If they fail to file the same for 2 consecutive quarter, then the same can get suspended. However, in any case, the stock exchange has to give reasonable opportunity of being heard to the listed company. And if they comply with the regulation immediately, then this might get revoked or suspended, but as the case may be.
I think there's a network issue at Anil sir's end, if I'm not wrong.
Okay.
So
He's on mute.
Yeah, I understand that, but then
Ankit, in the meantime, you can continue.
yeah. So I will also share what basically I understood are the listing obligations and disclosure requirements. Maybe we can then have a look at these compliance requirements together, Shivam, and talk about these from the point of view of a company which is under insolvency. So of course, these regulations, which are the LODR regulations, popularly known as LODR, listing obligations and disclosure requirements, are applicable to all companies. And then if this thing, wherever the companies have issued the following designated securities. So it's not always compulsory that the company should have listed shares on the stock exchange to be required or to have a requirement to comply with LODR. There might be a requirement sometimes that the company might have issued certain securities which are listed on the stock exchange, and therefore they might be non-equity shares also in some occasions. So then also these regulations are applicable. Obligations of course, listed companies where we talk about regulation 15(2)(a), and when we talk about regulation 17, this was an amendment here that no person shall hold directorship or assume the position of an independent director in more than 7 listed entities. So that's one compliance with respect to independent directors that is there. Then, of course, the provisions specified are not applicable to listed company which is undergoing CIRP under the code. So the independent director requirement is exempt through this regulation, through this amendment which happened in 2018. And it also now said that provided that the role and responsibility of the board of directors as specified under regulation 17 shall be fulfilled by the IRP-RP in accordance with section 17 and 23 of the insolvency code. So this is a notification which provided this relief with respect to the appointment of independent directors and maintaining a composition of board of directors, because we know that practically speaking, when we're talking about a company which is under insolvency, you would find you would have a lot of difficulty in seeking any directorships or appointing any directors in that company. Then we also have regulation 15(2)(b), and the provisions as specified in regulation 18, 19, 20, and 21 shall not be applicable in respect of a listed entity which is undergoing CIRP under the insolvency code. Regulation 18, 19, 20, and 21 then talk about how the 18 talks about listed companies should constitute a qualified and independent audit committee. So the audit committee requirements are then diluted for a company under CIRP as per regulation 18. As per regulation 19, we talk about nomination and remuneration committee, which is again diluted through the amendment or regulation 15(2)(b). 20, then of course we have 20 talking about composition of stakeholder relationship committee and so on. So 21, then of course this is how these are the amendments or requirements with respect to risk management committee, that is regulation 21. So these are some committees that are again exempted. What is the premise of these committees? The basic premise of these committees are that certain decisions with respect to the audit committee, with respect to other committees, there was some kind of independence given to these committees where the independent directors were supposed to have a minimum number of seats so that the overall corporate governance of the company is maintained. That was the whole objective of having these committees, which then report to or give the report to the board of directors, sparing more time for the board of directors to take up other matters. So these are, again, there is a relief here from the SEBI regulations within SEBI regulations. Then exemptions pertaining to related party transactions. So again, basically, Regulation 23 talks about how a listed entity is required to formulate policy on materiality of related party transactions. And then it talks about disclosures to be made by listed companies of defaults on payment of interest, repayment of principal amount on loans from banks, financial institutions, debt securities, etc. So here the periodic disclosure required under LODR regulations, we talk about broader principles for periodic disclosures and for corporate governance by listed companies. And the principle for periodic disclosure is that the information shall be prepared and disclosed in accordance with applicable standards of accounting and financial disclosure. Then the listed entity shall implement the prescribed accounting standards. So these are some requirements for periodic disclosure that are required, and these are then of course given based on the principles given by International Organization of Securities Commissions. Then of course we have there is another circular dated 2019 where the new circular, the applicability shall be extended to companies along with all listed entities which are listed any specified securities to NCDs and NCRPs as well. So it is an extension to companies where securities are listed on the stock exchange, even if those securities are not equity shares or not shares of the company. Elaboration on the definition of default. So default for the purpose of this circular shall not mean non-payment of the interest or principal amount in full on the date when the debt has become due and payable. It was also provided that for revolving facilities like cash credit, an entity would be considered to be in default if the outstanding balance remains continuously in excess of the sanction limit or drawing power, whichever is lower for more than 30 days. So this is how it is. Timing for disclosure. So entities shall make this disclosure for any default of loan, including revolving facilities. And this disclosure shall be made promptly, but not later than 24 hours from the 30th day of such default. So this is how the default is required to be notified to the stock exchange via this circular. Then this is an elaborate list of details to be disclosed by listed entities for each instance of default. So they would want for revolving facilities and for unlisted debt, then they would want the name of the listed company, the date of making the disclosure, nature of obligation, name of the lender, date of default, current default amount, details of obligations, total amount outstanding. So this is the kind of format.
This can be missed, Ankit, because this is not a requirement during CIRP.
Yeah, most probably during CIRP.
Would you say something on this, Shivam? This is not a requirement during CIRP, is it so?
During CIRP, certain compliances are not required, but disclosures are required.
Regarding debt and default, would there be any such requirement?
So basically, there can be two cases. One, there might be a default which has been going on long before the CIRP started initiated. In that process, I believe that the directors will continue to be responsible to give this disclosure. But in some cases where due to a default, which maybe the company has been fighting against in NCLT, a surprise admittance in CIRP comes up, then in my understanding, if the company is suddenly given an RP is appointed suddenly due to some admittance of default by NCLT, it will become the duty of the RP to then inform the stock exchange with respect to how the CIRP has initiated for the company due to this default being accepted as a default by the NCLT. This is my understanding, especially where the default was not previously known or not something which is clearly identified by the company. So disclosure required to be made by listed companies on last date of any quarter. So this is how then they are required to talk about total amount outstanding. So this is a quarterly compliance, which then talks about unlisted debt and listed debt and so on. So compliance and disclosure requirement for listed companies undergoing CIRP. So the objective is to maintain confidentiality here. All listed companies were required to adhere to the following with immediate effect. This is a June 2018 circular, which talks about how promptly they are supposed to inform the stock exchanges regarding the events pertaining to the IRP process, and as laid down under SEBI LODR and all amendments from time to time in IBC, and basically the disclosure is required by them. And then they've talked about how all participants who have acquired confidential information in the course of insolvency proceedings shall maintain the confidentiality of that that agreement, and then price sensitive information and all that would extend to the company, resolution professionals, committee of creditors, and other entities who have access to unpublished price sensitive information. And such participants should continue to ensure there is a strong and robust framework to maintain confidentiality of the unpublished price sensitive information, ensure that persons including resolution professionals, committee of creditors, and any other entities, then they are also part of that provision of insider trading regulation. Then companies are also required on their own to confirm or deny and clarify any rumors or news regarding IBC proceedings to stock exchanges which are not announced by them. So this was the requirement to them. Then SEBI and stock exchange compliances. Then we talk about these circulars with respect to ICA, that is the inter-creditor agreement and disclosure of default and so on. So we will primarily visit these three circulars which were related to this default and inter-creditor agreement. And so wherever this kind of restructuring is happening, inter-creditor agreement has been entered into. There again, SEBI has given some disclosure requirements. Then where we have direction issued by this circular was that the listed entity shall promptly disclose to the exchange regarding material developments. Then all participants who have acquired confidential information, and then companies shall on their own promptly confirm or deny and clarify to the stock exchanges regarding any rumors or news. So this is what we talked about a while back. When in relation to the guidance note for companies undergoing CIRP, this circular talked about how while acting as IRP, RP for a corporate person under code, an IP shall exercise reasonable care and diligence, take all necessary steps to ensure that the corporate person undergoing any person complies with the laws.
Can we ask the Shivam, how many specific circulars have been issued by SEBI for companies which are listed and under CIRP? So far, how many circulars have been issued by SEBI? Shivam?
Yeah, so SEBI has issued around, for the CIRP, they haven't issued any circular. They have issued only the guidance note, but they have amended the LODR regulation itself to accommodate the compliances by the companies undergoing the CIRP. So only the stock exchanges has issued various circular. Around 3 circulars have been issued by NSE and BSE both regarding the disclosures and maintenance by the company during the CIRP.
So I think there are specific circulars like the circular on the screen, which is the circular 2021 circular and July 9, 2021. And similarly, I have seen four or five circulars which are basically based on the chronological order. One is better than before based on the experiences. So
correct, exchanges circular.
I think yeah, the exchange circular. Exchange circulars are issued by exchange or it's issued by SEBI?
Exchange. So this one is issued by NSE because it says circular
This
number
way should,
NSE CML. So it is clearly NSE.
I think
So-
SEBI, like circulars or guidelines, whatever it is, that has to be, that are very, very important.
So SEBI has, as Shivam just shared, has amended the LODR regulations. We will come to that as well. I'll just quickly go through these. And I think the idea is that the NSE circular here, as we say, is also then talks about the IP required to ensure that company law is, companies comply with the LODR regulations. So of course, we can say here that the LODR regulations were amended in 2018 to accommodate certain changes here. And they also made changes in 2021. And the following disclosures shall be submitted to the exchange in addition to those already prescribed under the LODR regulations. So what are these three? Prior intimation of at least 2 working days in intimating about the date of hearing where NCLT would be considering the resolution plan. So that's something that is a requirement under this circular. Disclosure of the approval of resolution plan to be made to the exchange on oral pronouncement or otherwise of the order on immediate basis. So because these are important events that a resolution plan is being talked about whenever the NCLT is hearing that, the resolution professional shall inform through the exchange platform any impact on the existing holders, investors of listed securities on areas such as status of listing, the value of holding of existing holders, right of cancellation, extinguishment of any existing equity shares, preference shares, debentures, etc. Then companies, resolution professionals are advised to be guided by the provisions of the LODR regulations and advised to maintain the confidentiality of the resolution plan until details are not submitted on the exchange platform. So the idea, I think, is very clear that the whole focus of SEBI is that information, whatever is relevant with respect to the CIRP matter, should be disclosed at the adequate time. An important event like NCLT considering or proposing to consider the resolution plan is again an important timeline which the SEBI wants information of from the insolvency professional, liquidator,
Yeah.
IRP.
Ankit, can you hear me?
Very much.
Yeah, so I just wanted to share in relation to your previous questions, I could only hear. So the reason behind why SEBI does in relation to LODR and then NSE and BSE follow suit by way of circulars is that they only get into surveillance measures till the time that NCLT actually approves it. So as we have seen in the case of Syntex, wherein by way of appeal in SAT, it was clearly said that they cannot suspend trading if it is only on account if it is not on account of CIRP being approved by NCLT. They can only do so on account of non-compliances under LODR. And if these non-compliances, to make it as a going concern and run it till the CIRP process is approved and the resolution plan is approved, the resolution professional can take out the entire compliance into his or her hand and comply with the entire listing obligations and keep on going in order to ensure that as and when he's sure or there is a possibility of compliance, then he will ensure that there will be no problem per se in relation to listing getting affected and the shareholder per se getting affected if whoever is the resolution professional coming, as in whoever is the next owner of the company taking over the company, then there is, and he wants to ensure that listing goes through, say in case of Ruchi Soya by way of FPO, then it is the obligation, and SEBI by way of surveillance measure ensures that listing is not suspended if they are going with all the compliances, which is why they have given surveillance measures of trading once a week in form of IBC 1 and IBC 2.
Yeah, and one more thing I have to add here. You have mentioned that the company has to disclose the approval or rejection of the resolution plan to the exchange within 30 minutes. The rationale behind putting this measure is to suspend the trading of the listed company. If the resolution provides that the the value of the equity shares will be delisted or extinguished. In such scenario, NSE and BSE will take immediate action against such company to suspend the trading. However, if the company has been compliant during the CIRP, they cannot terminate the listing. So only once the NCLT approve, or even the oral order required to be within 30 minutes, then they can take action to suspend the listing.
This is actually very important, Shivam. But then we think
Anilji, just
yes, please.
yeah, sorry sir, just to add here, so why they say that it is important, SEBI ensures that even in case of suspension of listing, if it is not in relation to, you know, approval of the resolution plan and only in non-compliance, then also the stock exchanges are under an obligation by way of a legal principle called audi ultram partem, wherein they have to give an opportunity of being heard to the company or the resolution professional that why the trading must not, as in it must not be suspended. And if the resolution professional files a plea and give a detailed answer and say a reasonable time that in this particular time he will or she will comply with the non-compliances and ensure that compliances will be put in place, they will not have any right to suspend the trading, and SAT will overturn it, just like they gave it clearly in case of Syntec Industries in the matter of Brijej Singh Bhaduria versus NSE. Sorry, sir, please go ahead.
I think what I was trying to say, what should be
Sir.
the capital structuring in a resolution plan? In what kind of cases the company automatically gets delisted on approval of resolution plan? What is the requirement of having public shareholding of 25%, 10%, and 5%? That is something that we would like to deal with part 2, because see, part 2 is going to be, because see, presently there are a lot of questions in the minds of the audience, and especially my professional colleagues who are handling the listed companies, and hardly the clarity is not really seen. And I believe the value is depleting, because normally a listed company would also have a value, and as against an unlisted company. So that will handle in the second part of this subject, which will come up in the next
So I think Anilji wants to say that yes, this part we will talk about in part 2. But in the meantime, I believe we can take up some questions. So Arun Srivastavaji is asking how voting power is worked out during CIRP when powers of directors are suspended. So to this, my understanding says that the voting power with respect to board of directors meetings is something that would not be very relevant, because the board of directors are suspended during CIRP and they are not a function, that will not be a functioning board. With respect to the voting power of shareholders, there the voting power would continue. So the process of having maybe some shareholders meeting to maybe pass some resolutions that are required to be passed by them would continue during CIRP. Any other point of view here, Shivam, or anyone from anyone else?
I can add one thing. So in the IBC, it is written that the power of the directors will get vested into the IRP, resolution professional particularly. So all the voting powers of the directors will be exercised by RP only.
Understood. So directors' voting powers are transferred to the RP. That's very clear. And the directors' meetings and all that will not function. But for shareholders' meetings and maybe for an AGM approval, there again that process will continue based on the voting power, based on the actual shareholding, right? As it is, there is no change in the CIRP there. Then
yes, there is no change during CIRP regarding shareholding or regarding the powers of the shareholder. There is no change.
Yes.
Even if the company is listed or not listed, the powers of the shareholders will continue and without any change.
Yes.
That's it is.
Then we come to the question posted by Mr. Zitendra Rao Dendukuri. He's saying that INC 28 should be filed by RP or IRP. And then he's asking if in case there is stay on CIRP proceedings by NCLAT within 30 days from the date of CIRP without cancellation of CIRP, should we file INC 28? So,
Ankit, INC 28 is the first thing that the IRP should file
yeah.
immediately on being appointed as IRP by NCLT. In case he gets confirmed as RP, then the same INC will continue and he will continue to be CEO as prescribed by the MCA website. And in case a new RP is appointed, then the new RP will also file INC 28 so that his name is replaced in the records of MCA for filing all the documents. Then again INC 28 would be filed for closing the process. In case company goes into liquidation, then the liquidator will file the INC 28 so that the liquidator gets the power and also the status of the company gets changed from CIRP to liquidation. The liquidator will have the power to file INC. So these are the requirements of INC during CIRP and during liquidation.
So, perfectly okay. So basically, we are saying that INC 28 will be required to be filed by the IRP, and as Anil suggested, that even if there is a stay granted by NCLAT, the fact that there is an insolvency order, despite that stay, the CIRP process does continue, the moratorium continues. So, therefore, maybe the INC 28, that's our understanding that INC 28 should be filed. So that the status of CIRP with respect to the company is there. Although other things, of course, change due to a stay of the order by NCLAT. Then there is a question from Mr. Kapil Mantri. He says that if RA wants to keep the company listed, can RA reduce the capital of selective shareholders and give 5% to anyone? Any guidance in this regard, case laws, etc.? So I think
according to my understanding, or in case Sumit would like to add, I think he would be welcome. According to my understanding is that yes, there is a requirement of 5%. That is very important, and that requirement of 5% is. Am I audible?
very much.
So that requirement of 5% public shareholding has to be retained for continuing listing.
Yeah.
Now, in case, suppose 100 are the total shareholding, out of the 100, only 40% is the public shareholding. So that means the resolution applicant can propose that the public shareholding will get reduced to that extent, so that the public shareholding becomes 5% of the total equity of the paid up equity of the company, and the rest of the shares, which may belong to promoters or promoter companies or institutions, that can actually get transferred. That can actually get transferred to the nominees of the RA at zero value. The question of Kapil Mantri, can you, Ankit, see what exactly within what is the option that he's asking for RA?
So I will try and answer this. My understanding is that when the resolution plan is presented before the COC and later the NCLT, the resolution applicant has two options. One, he can choose to keep the company listed. Alternatively, he can make the company go through the delisting process. In case the resolution applicant says that the existing capital is reduced to 0%, then the company, then the regulations say that the company would automatically get delisted within those 30 minutes from the passing of that NCLT order, and the trading of the shares will stop, so that there is no nobody who who purchases those shares, because they are anyways extinguished while that NCLT order being passed. However, in case the resolution applicant says that I will reduce the shareholding to an extent where I will continue to have 5% of the overall capital of the company uh, uh, to be available to the public at large, then the listing can continue subject to the compliance of LODR regulations. Uh, Another aspect to this is that the regulations also say that in case the resolution plan talks about giving any value to the promoter or any other shareholder during the resolution process, then the same has to be offered to all the shareholders. One cannot say that I will give this much rupees to the promoter in exchange of his shares or in exchange of diminution of his shares and offer nothing to the public shareholders or the other shareholders. So maybe Shivam or Sumit ji can add if I'm missing anything in the overall perspective with respect to the 5% threshold. With
Yeah,
respect
so
to the selective shareholders, my understanding says that it is possible for the resolution plan to say that the promoter's shareholding is completely reduced and the other shareholders are reduced in a different fashion. Over to
I
you.
think I have this option, but then yes, I think I need expert opinion in this case.
So maybe Shivam can share his views, Sumit ji can share his views.
for this query, COC meeting,
No, for the purpose
selective.
of, whether we talk about selective shareholding and we also are talking about the options available with the resolution applicant with respect to keeping a 5% public float versus delisting the shares. And then, of course, the idea that in case the promoters are offered any shares or any shares or any money against their shares, then the same offering has to be made to the other shareholders as well.
Yeah, so basically there are three options. First option is to reduce the complete shareholding share capital, and the new promoters will come in and take the 100%. So if the promoters does not want to get the company listed and they want to take the control over the company in future, once they resume the position of directorship and the shareholder, so it is preferable to reduce the shareholding to complete 100% and get the company delisted. And the exemption under the delisting regulations has been provided. So rigorous compliances is not required under the delisting regulations also. So second case is to keep the company listed. Now to keep the company listed, there are two types of shareholders, promoters and public shareholders. So erstwhile promoters will get, they can reduce the shareholding of the erstwhile promoters who were non-compliant during the, when the company was running smoothly. They were non-compliant when then CIRP started. So in that case, what they can do is they have to do at least 5% of the public shareholding post implementation of the resolution plan. Okay. So at least 5% has to be maintained, at least. So this happened earlier. There was no limitation of 5% of public shareholding after the implementation of resolution plan. But due to the Ruchi Soya Industries Limited case, in which the promoters acquired 99% shareholding and the public shareholding got reduced to 1% only, since they have infused 4,000 crores in the company, so their shareholding goes up to 99%. But at such point of time, the share of the company was around 10 rupees. And then after they completely acquired the 99%, the share of the company goes to 1,000. So in that case, the share pricing got distorted due to the limited supply of the shares in the market. So due to this reason, SEBI came up with the requirement that at least 5% should be maintained post resolution plan of the implementation of the resolution plan. So 5% public shareholding has to be maintained, and that has to be reduced within next 12 months to 10% and within next 3 years to 25%. So minimum public shareholding of 25% has to be maintained within next 3 years.
Got it. So I think that's the
Ankit, you can see if there is any other question. Yes, I think
So, Mr. Madan Vaishnava is asking that powers are suspended, not duties of directors. The other interpretation would be in board meeting, they are duly bound to exercise the voting. Even powers are suspended, not duties. Suppose some contract is to be awarded to related parties or other parties during CRP. In such scenario, who will decide and vote as per Companies Act? When as a shareholder, the directors can vote, but not during the board meeting. I think there is a anomaly in such interpretation. So, Madanji, I think it's very clear that during CIRP, the board of directors are suspended and the powers lie with the with the RP, with the insolvency professional who is taking care of that matter. With respect to the
For
contracts
related parties,
being,
definitely.
with
Yes, Ankit, I
respect, so with respect to the contracts being awarded to related parties, there the duty of the RP would be to make sure that if there are any related parties involved in the process of keeping the business as a going concern, then that is correctly brought to the notice of the COC, properly monetized that yes, this is the business model of the company without which the business cannot be run or cannot be continued as a going concern. And I think that scenario is what will continue, because the powers with respect to sanctioning the financial expenses during the CRP period would be retained by the COC, which will be then exercising its powers through the RP.
So Section 28 of the IBC talks about approval of committee of creditors for related party transactions during CIRP. So I think the answer would be that the COC has the power to sanction contracts with the related parties.
So Hemanji is asking that 5% share limit applicable to companies whose shares were delisted prior to CRP commencement. So no, Hemanji, we are saying 5% limit is applicable to all companies where the resolution applicant wants to continue the company as a as a listed company on the stock exchange post the implementation of the resolution plan. That is what we're talking about. Vishwanath ji is asking that so option of making capital zero in case of listed company does not remain. That is not the case, Vishwanath ji. As we said, there is an option for the resolution applicant that they can keep the company's public float as 5% or zero. In case the resolution plan talks about the public float to be reduced to zero, then the company will automatically stand delisted and the trading will stop on the stock exchange. And then the company can always go back to the stock exchange through an IPO or through another mechanism, but that will be a fresh process. It will not continue its older registration process. That's what we were saying. And so COC meeting outcome needs to be given to stock exchange. That's a question from Nitish ji. Is there any requirement for COC meeting outcome to be given to stock exchange? I don't think so. Shivam, maybe you can clarify further on this.
Yeah, so there's a para number 16 and schedule 3, which was inserted by SEBI for disclosure related to the CIRP, whatever happened during the CIRP procedures. So as per that para number 16, post and pre and post facto intimation of the meeting is required.
Okay, so the COC meetings are also required to be, and any specific guideline on what all events with respect to the COC are required to be made public, or only the fact that the COC meeting is happening or has happened?
Yeah, all the meetings are required to be disclosed of the COC.
So the minutes are not required to be disclosed. The events during the meeting are not required to be disclosed, right? Only the happening of the meeting. Only the happening of the meeting. Okay.
Correct. Also, Ankit, in relation to previous point of delisting, I would like to add, since I have internet, that the delisting, though it is automated by the order and allowed under Regulation 3.2 of delisting regulations, but the resolution applicant in the RP needs to make a specific application and pay the hefty sum of fees to stock exchanges for the processing of delisting as well. So that is also there, and that is another tiring process.
Okay. So I think we are through with almost all the questions. We have a few questions that are remaining, but we have crossed our 12 o'clock time. We are anyways planning a part 2 with respect to these regulations and understanding the SEBI regulations with respect to a listed company. So I believe we will have to continue this this discussion next week, and I think
I think the next week, Saturday, 11 a.m., we would be more comfortable and internet would be stable, at least for me and for
Absolutely,
Sumit
sir.
Kochar, at least for me and Mr.
Absolutely, sir.
Kochar. I will also not have so much of noise around me. So we would be able to deliberate more on specific questions of listing, capital structure, delisting, and, and specifically when the resolution plans are approved, how to get the revocation of suspension and how to get finally the company listed. These are the issues that we will actually handle the next Saturday, 11 a.m. So thank you very much, all participants. Thank you very much, Sumit. Thank you very much, Shivan. And thanks, Ankit. And we will come with better preparation and next Saturday. Thank you. Thanks a lot.
so. Thank you, everyone. Thank you. So looking forward to see you next week. Thank you,
Thank
everyone.
you, everyone.
Thank you, everyone.